announcement of judgment, WBC 6975-2023.
लाइब्रेरी किताब है कौन घुराई लिया चलो ना यार चलो क्या नहीं. From the discussions made above and from the materials on record, this court is of the considered opinion that the impugned order of rejection dated so-and-so has taken into consideration the relevant factors, and the decision to reject is based on cogent materials, including an interpretation of the scheme of 2017. Powers of Judicial Review on 226 is only to examine the decision-making process. In the instant case, such process appears to be based on relevant material. There is no allegation of mala fide or taking into consideration extraneous factors. The petition is dismissed.
Please.
Doesn't it?
ठीक है एक सर ये कौन प्रॉपर्टी नहीं अभी कौन सा
Article 21.
Upon consideration of the materials on record, this court is of the opinion that a case for enhancement of the permanent alimony is made out. Though the appellant has claimed an amount of rupees 18 lakhs only, this court is of the opinion that considering the facts and circumstances and striking a balance, a total amount of rupees 10 lakh only as permanent alimony would be justified. We accordingly direct the respondent to pay the balance amount of rupees 5 lakhs within a period of 3 months from today, which the appellant would have the liberty to withdraw. Appeal stands allowed in the manner indicated above.
Okay.
Please, Your Lordship. Lordship, I beg to mention for listing of one matter appeal, Your Lordship.
Fresh appeal, fresh matter.
Not fresh, Your Lordship. It has already been listed earlier, Your Lordship. Earlier on last occasion, Your Lordship, the appellant was directed to file additional pleadings, Your Lordship. He is not making any payment also, Your Lordship. So why?
When do you want?
Lordship, on 3rd of October for orders, Your Lordship.
3rd of October will be difficult. We'll have it after the vacation. I have it on 23rd.
4th, Your Lordship, on 4th of
These 2 days will be difficult. I have it on the reopening on 23rd.
May I please, Your Lordship, I beg to mention item number 15.
Yes.
This matter may kindly be adjourned for a day as the engaged counsel is out of station.
Who's the engaged counsel?
Kamar.
On a yes, PP. Madam, on a prayer made on behalf of the appellant, matter is adjourned to be listed after the puja vacation. Yes.
And also, Lordship, item number 10, the engaged counsel P. Kotoki has some personal difficulties, Lordship. Item number 10.
Okay.
The informant side is also not here. I was told by D. Bura Bor Pujari.
Okay.
She has an additional prayer that she didn't get the papers. She was supposed to file out.
Is she around? No.
No, she is. She has gone for father's
Okay,
last
okay,
night.
okay. We'll have it after the puja vacation.
Lord.
Same order, huh? Item 10. Yes. I is for what, madam?
I is for suspension.
Okay.
May I please, Your Lordship? I beg to mention item number 12, Lordship.
Yes.
This matter pass over for the day, Lordship.
Delay for there is
Fresh matter.
there is a delay for her.
First time it has come.
Yes, Lord.
Why are you getting it? Pass it over. Pass it over.
No,
Adjourn.
my senior is B. Jamar, Lordship.
How does it matter? We'll issue notice on the delay condemnation.
What
was the amount
of delay?
We're not passing any adverse order. Let it proceed.
Delay to notice to job.
So delay condemnation, we'll issue notice. You be here. Did you
No,
have the file or not?
not.
You look at the court's file, have a look. It's delay condemnation, madam.
Perhaps.
I
file
think
it
of
number.
some medical problem, Lordship. My instruction,
Understood. We are not going to pass any adverse. It will proceed. We'll issue notice on the delay condemnation. It will not be adverse to you. It will be one step forward. Okay, just check the records. If it is something else, then we'll not take it up. Otherwise, delay condemnation will issue notice. Just check up the file.
Please, Your Lordship. Lordship, I'm appearing on behalf of Amtarania. I beg to mention item number 13. As a senior counsel, he is having some personal difficulties. Kindly adjourn the matter for today and fix it after vacation.
5 to 12, who are 5 to 12? Are there
5 to
any?
12, yes, P. Borua is.
No, no,
appearing.
who are 5 to 12?
This is an appeal against acquittal. These are accused persons.
Okay. Informed or not?
Inform-
Have you informed the other
He
side?
informed us,
Yes.
but I don't know about.
No, no,
the-
5 to 12?
Yes, Lordship.
Okay.
Inform which one?
Of course.
Oh, yes, inform.
Item number 17 matter, okay. Same,
Accept.
no? After Puja vacation. Appellant. Same. Okay.
Obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 8 of the daily list, Your Lordship. Lordship, the engaged counsel, Ms. S. Sharma Hazarika, is indisposed due to personal difficulty. Pray before the Lordship to adjourn the matter and visit after the vacations, Your Lordship.
Okay. Behalf of appellant, Puja vacation. Same.
Item 1. For independence of.
This is a jail appeal coming up for the first time.
Yes, my lord.
Madam
Appeal
Sultana,
amendment.
you are appearing as legal aid counsel.
Yes, my lord. 374, my lord. Conviction. Boxer Act, my lord.
And the other matters are all from the same judgment.
District, the first case is in Morigaon, my lord, and second and third is the district Sipsagar, my lord.
And, okay.
20 years,
Different.
it is different, my lord.
Okay. All the 3 cases are different.
Yes, different, my lord.
Okay. Here. Here. Here.
Serial number.
Thirteen to mention kursi matlo. No, 13.
is-
Third,
Section? Excuse me.
Miss B.R.A. Sultana, Learned- Legal Aid Counsel, who has preferred this appeal against a judgment so and so, huh? Passed by so and so. Admit. Call for the record. Ms. Ed Jahan, learned APP, Assam, accepts notice on behalf of respondent number 1. Steps for service of notice upon the respondent number 2 be taken through the registry in the manner prescribed. Steps within 2 working days. Same order.
In respect of 2 and 3.
Okay, same. How many private respondents are there in the others? 1.
One.
Informed.
Informant.
Okay, same. Judgment order কেটা বেলে হয়ে যাব খালি তাই লব 1, 2 and 3 similar. Yes.
Item 4.
This is also a jail appeal.
Jail appeal.
Yes,
Conviction under
conviction, life imprisonment,
302.
302.
Okay, same, huh? Against R. Islam.
I am for legal aid counsel.
Legal Aid Council. And one accept by H. Jahan, APP. 2 by usual process. Steps within 2 working days.
Mat.
Judgment get a silo first.
Item 5.
Legal Aid Council.
Lordship, legal aid council and it should be criminal jail appeal, Lordship, but I file it as jail appeal and register it as a general appeal.
Doesn't matter. B Sharma, huh? Legal Aid Council against Swenson. Okay, habo. Ekdom okay habo. Usual process. Steps within 2 days.
I think he'll face problem if it is not jail
Yes.
appeal in respect of our
Paperwork,
remuneration.
etc. That is a difficulty.
So paperwork registry will prepare
About the remuneration that he gets as a legal aid.
Legal Aid Council.
But that will not any
No, any-
problem. Because I am appearing as a legal aid counsel,
No,
only
okay,
the
doesn't-
registered
doesn't make any-
parties there. Of that.
We'll take care of those things, don't
Done.
worry.
Item C.
I don't know, I don't. Oh,
May I please, your lordship? Lordship, this is a statutory appeal, lordship, that the appellant lordship convicted lordship under section 6 of
Six.
Poxo Act for life, lordship.
What is your name?
Lordship, I.U. Chaudhary, lordship.
I.U.
I.U.
Chaudhary,
Chaudhary,
huh?
lordship. Impugned judgment on file, page 16, lordship, start from page 15, relevant lordship.
Preferred this appeal, okay, I.U. Chaudhary, again. Admit सबके होगा, call for the, सबूरे call for the request है वो, हाँ? और एक, Jahan 1 or 2, through the registry in the manner prescribed. This is POXO?
Yes.
Poxo, lordship,
Okay.
pro 3, lordship.
Okay, so और बाकी सबूरे लिखे हुआ list after 6 weeks along with a report on service as well as LCR.
Deputy.
सबके ठीक हो, हाँ?
I is there.
I is there, lordship.
I let it remain.
After
Let
receipt of
LCR.
LCR, lordship.
Item 7.
Okay.
Two copies. No, I'm giving a regulation, because two things are there. One is the prescribed qualification for appointment of principal in a diet college. That is given by the NCT regulation. Your lordship will kindly see, I think there some flag mark is there. Flag mark is there,
No flag mark.
flag B, my lord.
So Das, you should give 2 copies. We are 2.
We have 2 copies. My lord, only my junior counsel is
No, only you can give, could have given the relevant pages. All the entire regulation is not necessary.
not necessary.
Only the relevant pages.
Regulation is marked, huh?
It's not marked.
Yeah, no.
What is it?
First regulation, your
No,
lordship will
what is
kindly-
it about? What is the appeal about?
The appeal is, my lord, the court held
You,
that there is a rules.
who are you?
I am a person, my
You-
lord, who
no,
has
no, you're
passed
You're
LL,
the
who has passed
petition.
PhD,
You're
yes.
the petitioner.
Yes. one
Your
of the-
writ petition has been dismissed.
Yes, my lord.
Okay.
So I passed PhD. So as per the requirement of NCT, my lord, regulation, the requirement is PhD. So if the requirement is PhD, even if the rule says, my lord, your MPhil and MA, the requirement of the NCTs will prevail. That is the judgment, my lord. I will give you one judgment.
Now, what has been held here in your case?
Case held because the rule is there. So therefore, my lord.
No, in your case, what has been held by the learned single judge?
Single judge held the rule is that the service rule 2010 is there. So therefore, we cannot look into this NCT regulation. That is against the judgment, my lord. 2 judgments are there. I'll give.
Hazarika for whom?
My lord, I am for the caveat, my lord.
Hey, what of-
The impugned judgment was arising out of 2 writ petitions, my lord. My lord, in the writ petition, my lord, who is, my lord, the appellant has appeared, my lord. There we are not respondent, my lord. I am the respondent in the other writ petition, my lord. Here also in the appeal also we are not the party, my lord. Therefore, I have instruction not to, my lord, praise the caveat, my lord.
You are not parties here.
Not parties here, even in this, my lord, honorable, in the writ petition filed by the, my lord, the appellant. In the- before
KVIT
this-
is not connected then.
Yes,
Your KVIT is not connected, will not,
Very good.
who's for the education department?
Education, my lord, is the party here. My lord.
Huh? Education, who is for education?
Even my lord, in the petition also, we are not party in the
Understood.
honorable single.
Where is elementary education?
Like the,
Name shown in the cause list or not?
what will there?
Mr. Chalia, you are for finance department. Where is education?
Yes, my lord, their name has been shown as S3 elementary education.
My lord, your lordship may kindly say 2016 SCC 110.
Yes.
There, your lordship will kindly see that is that regulation is must. Your paragraph 1, your lordship will kindly see. DB allowed the students for admission for academic year 2015-16, subject to fulfillment of new guidelines.
Paragraph 1 you are reading?
Yes. The crux of the controversy is at page 2, paragraph 2. The crux of the controversy is whether the state government has any say in the matter of grant of recognition to the institutions which apply for establishing the institutions to get recognition from the NCT under the National Council for Teachers Education and the regulations framed thereunder. Then, yeah, my lord, I will not take your lordship's much time on this subject because this is regarding recognition. State government doesn't have anything to say in the matter. Somebody will apply, it has to be decided by the NCT. Paragraph 16. I'm taking it short because next case is important for me.
16.
Paragraph 16. As we find from the aforesaid authorities as well as the regulations framed by the NCTE, the state has a say, maybe a limited one. We are inclined to use the word limited because the state's say is not binding on NCT. However, NCT is required to take the same into consideration, for the state has a vital role to offer proper comments supported by due reasoning. It needs no special emphasis to say that final authority rests with the NCT. It is the clear legal position. So NCT is now next law, your lord, that is what I rely on. Page Matlab Kerala case. I think flag mark is the Kerala case.
It's a part of the paper book.
Yes, paper book there. Yeah. Judgment is there. Where is my judgment? My lord, it is para 4, your lordship will see, because it has discussed lot of cases, my lord. Para 4, may I read, my lord?
Yes.
Para 4, the 7th respondent challenged the petitioner's appointment before this court by filing so and so, that the writ petition was disposed of, directing the consideration of revision filed by the 7th respondent before the government, challenging the appointment of the petitioner. The government by Exhibit 7 order held that even though NCT has prescribed the qualification for the post of principal headmaster of PTI as master's degree and MEA degree with 55% marks, the said prescription has not been implemented in TTIs as yet by any executive order of the government or by way of amendment to the Kerala. It was therefore held that for the purpose of appointment as headmaster in training school, the qualification prescribed under rule so and so, 12 years of continuous service with pass in Kerala and accounts test conducted by the KPSA subject to the provisions of rule 44(1) regarding seniority would be sufficient. The government found that the 7th respondent who was admittedly senior to the petitioner had the qualification prescribed under Kerala and set aside Exhibit 5 order of the PTO, and consequently the appointment of the petitioner and directed the DO who was officiating as the manager. Now paragraph 6, your lordship will kindly say, the learned counsel for the petitioner relied on exhibit so and so judgments of this court and the decisions in University of Calicut to drive home her contention that the qualification for appointment to the post of principal headmaster having been prescribed under by exhibit P1 regulations of the NCT, the government committed gross illegality in setting aside the petitioner's appointment and paving way for appointment of the 7 respondents as headmistress who admittedly did not have the qualification prescribed by NCT. Now 7. So ultimately, my lord, paragraph 9, your lordship will kindly see.
Page,
Paragraph 9. Paragraph 8 and 9, paragraph 9, page 10. Exhibit P3 judgment rendered in so and so. Also, the contention of the petitioner was that NCT being the supreme central authority competent to prescribe educational standard for teachers attaining institutes, the qualification prescribed by the NCT for appointment as headmaster are mandatory. So this is what I want to say, and therefore no person who does not possess such qualification could be appointed as headmaster of a teacher. So your lordship will kindly see this qualifications prescribed by the NCT is PhD degree. That your lordship will get it in paragraph page 112 of the NCT regulation.
Mr. Khataniar, you are there for the education department.
madam.
What do you say?
I need some development. The case was allotted to someone else, but somehow I came to know that he literally.
This is important in a sense because, my lord, NCT regulations in the year 2017 by notification, NCT regulation provided, my lord, that for the purpose of principal of a college, my lord, who teaches B.Ed and all, then the qualification has to be PhD. Now,
Okay, we'll have it on Thursday. Are you there on Thursday?
yes, only one page I'd like to show it before your lordship. Notification dated 5/12/20. Page, I think, my lord, it is 120.
Mr. Khataniar, he's trying to make out a case that the appellant fulfills the requirement under the NCT,
Yes,
and therefore, an NCT would prevail.
Yeah.
And therefore, the dismissal of the writ petition is not proper. You have to-
Page 124, Lanet Single Judge held, my lord, there is a state regulation, so therefore the state regulation will. Because no scheme has not
But
been
there is an,
adopted.
there.
Now, one aspect of the matter, 124, your lordship will kindly see. Page 124, this is important.
124 of the regulations.
No, of this.
Petition.
writ appeal. Madam, I'll just read this paragraph. This is important. Whereas education being the subject of concurrent, this is recognized by the under the NCT. They have taken affiliation of the NCT. Whereas education being the subject, has a lordship got it?
124.
124.
Yes.
May I just read the paragraph? Whereas education being the subject of concurrent list and NCT being the statutory body of the Government of India for teachers' educations has prescribed norms of teachers education courses as well as the qualifications of teachers' education as per the NCT norms and standard. Most of the fund in this regard is being borne by the Government of India for conducting teachers' education program sustaining NCT recognition. Keeping above in view, the Governor of Assam is pleased to revise the existing minimum qualifications for all categories. But while doing so, my lord, they have not taken into consideration the principle. All these categories are there, 28 categories are there, my lord, that has not been annexed. But PhD, but for principal, nothing is there. A notification to teacher that.
Where is the discussion by the learned single judge?
Learned Single Judge has discussed the matter at page. Page 28, page 34, man.
I think.
Yes.
Page 34.
Hmm.
Points, page 37, man. Points for determination. It is not in dispute. Page 37, is a lot to good.
Yes.
Paragraph 17.
Yes.
It is not in dispute that in the final gradation list on so and so, the name of Dr. Deuty, Doctor, the petitioner and so, that is the present appellant, appears at serial number 131 and that the final gradation list is on dated 31/5/2023. His name appears at serial number 36. It is also not in dispute that in the final gradation list as on so and so, the name of Dr. Sopon Shikhar Chaudhary, the petitioner in so and so, appears at serial number 256 and that in the final gradation list as on so and so her name appears. Now paragraph 20, as per the selection board minutes dated so and so, which was held for promotion to the cadre of principal of diet, there were 17 vacancies, out of which 14 posts were for unreserved categories, 2 posts were reserved for STA and 1 post was reserved for STP. The learned senior counsel for the petitioner has submitted that 68 numbers. My lord, I think your lordship may come to page 39, paragraph 25, page 39. As per Rule 5.1 of the Assam Diet Service Rules 2010, the post of principal is a promotional.
No, we are
post.
looking for the consideration on your submission that when NCT notifications are there, it will override.
Yes.
Where is that discussion?
That discussion, it has come from paragraph 25.
25 is not there.
Yes, as per the legality of the state rule.
It's not there.
As per notification dated, which is the government of Assam, it has discussed, my lord. The paragraph 27, my lord, therefore the petitioners have failed to demonstrate that there was any fault whatever with the decision taken by the selection board in his minus decisions, thereby recommending names for filling up the post of 17 post of principals. The court is inclined
Okay,
to. hold that-
Thursday we'll have.
Yes, it is there. It is, that is the only ground. Because 2010 is there, it has not been accepted by the government, adopted by the government of Assam. So the NCT regulations will not.
Part 3, BD Das Learned Senior Counsel
Okay,
for the appellant.
Okay, okay.
Sri N.J. Khatunir, Learned Standing Counsel. Elementary education,
Yes, my lord.
however, praise for
It is that-
a little accommodation. Para, list for admission on Thursday.
Yes.
Third,
Yes,
Name of the standing council, SCRT may be shown, my lord.
who is for SCRT?
Mr. P. Gogoi and P. Nayak.
Standing Council, SCRT, be reflected in the cause list. You can place this
take
on
the
the,
regulation,
on the,
I'll
on the
flag
next date.
like,
My lord,
And give the relevant pages. all
Yes.
pages.
my lord, Mike, maybe.
Kevin is not connected. You are not even a party.
But I am
Yeah,
not the
they-
party. It will also in the repetition also.
Not.
Okay.
How is the Kevin?
we cannot.
Hello, sir, it's out of similar judgment, my lord, that's why my lord, our name is.
Third. S. Hazarika,
My lord.
Learned Council,
Obligation.
who has lost, we are discharging the caveat, but it's
No,
not
no.
connected. We are just discharging it. Learned Council, who has lost this caveat in respect of a judgment and order dated so and so, side above. It however reflects, it however transpires that the caveat is not a party, was not a party in the connected WPC. In
My lord.
regard to which the appeal has been referred,
Right.
and only in a and in an analogous matter, the caveat was a party, full stop, para. In view of the above, comma, no orders are required to be passed in this caveat, and the same is accordingly disposed of.
I'm deeply obliged.
Milord, may kindly take writ appeal number 332, Milord.
20,
Yes.
item 20. 332 to like the second.
My lord, way back in 2012, Milord.
Just a minute. Second to table. Item number 20.
7. It would have going.
My lord, this writ petition is of the year 2012, my lord.
You are the writ petitioner.
No, my lord. I'm the respondent number 7.
Number 7.
Respondent number 17, my lord.
17
One second.
in the writ petition.
Yes. Now an advertisement was issued, my lord, for appointment to the post of inspector of school.
Writ petition is 2012.
12,
Okay. Advertisement.
yes.
For?
Advertise for appointment to the post of inspector of school, district, elementary education officer, etc. Same cadre, my lord. And the petitioner, respondent number 17 was appointed, and it was put to challenge
The advertisement was of which year?
11, my lord.
2011.
Yes.
You were selected and appointed?
Yes, yes.
Or
Page
se-
number 62 is the advertisement, my lord.
Okay. R17 selected and appointed.
Yes. Itu case to the respondent. My lord, in the other appeal, I am respondent number 4 in the writ petition. Here it is 7.
Okay.
My lord.
In both the cases, you are respondents.
Yes.
Your appointment was put to challenge.
Yes.
By the same separate parties.
2 persons, my lord.
Okay.
Two gentlemen. One is Hiranyo Kumar Nath. I don't know.
Hiranyo Kumar Nath, Anup Hazarika.
And Anup Hazarika. Anup Kumar Das, na Hazarika.
No, no. Anup Kumar Das is the appellant. Petitioner is Hiranyo Kumar Nath and Anup Hazarika. And in other cases,
Yes. Now, my lord, what had happened in the writ petition, there is no allegation against respondent number 7. Regarding other selected candidates, there are allegations.
Oh, there were other selected candidates,
Yes.
made parties,
Yes.
16 in all.
just like you.
In 16 in all.
Okay. 16 private respondents.
Yes. And my lord, there were allegations in respect of all except the appellant respondent number 17.
Okay.
Now, my lord, what had happened, a criminal case was subsequently registered. In the criminal case,
Against you.
yes, against all, my lord,
The selection.
against the selection process, against respondent number 17, the present appellant, my lord, a charge sheet was filed.
The criminal case was with regard to the selection process.
Yes. And regarding, my lord, there are certain documents.
Okay. Investigation over charges
Yes.
given. Okay.
Now, my lord, because in the charge sheet, the present appellant was named, therefore, my lord, during the course of the proceedings before the learned single judge, the writ petitioner elected not to proceed against others. So he invoked the doctrine of election.
Please come again.
Based on the charge sheet, my lord, what the writ petitioner did before the learned single judge, he withdrew his challenge, required the other respondents.
You are the only one who was named in the charge sheet.
Three.
Three. Against
So
three
he
has
says-
proceeded.
Yes. So writ petitioner maintained the challenge in respect of the 3, and regarding others, he gave up the challenge.
We
Now there is no dispute that the writ petitioner participated in the selection process and he was unsuccessful. And my lord, I'll show one very relevant thing from the impugned judgment. If your lordships will kindly come to page 319.
Yes.
Now, if everything was bad, how come the petitioner has been directed a consideration, my lord? Para 56, page 319.
Page 319.
Yes, para 56. If the selection process was bad, how come the petitioner is, my lord, taking advantage of that selection? And how come learned single judge has accepted that plea of the?
Just a minute, please.
Yes,
319. Yes, last
Yes.
page.
Yes, my lord, last
Yes.
page of the paper book, para 56. It is further provided that the respondent authorities may consider the appointment of the petitioners in view of the fact that petitioners have secured marks which position them just below the last selected candidate, and the two selected candidates have opted not to join the post in question. If, my lord, the selection is so bad that it calls for interference, how come, my lord, the petitioner can be directed to be appointed based on the same selection?
No, but has the selection been set aside?
No.
No. No, not the whole selection. Now, what the learned single judge has done, my lord, learned single judge has instead directed an inquiry. Now, please come to the impugned judgment, my lord. If your lordship will kindly come to page 315. Kindly permit me to read this 3-page, my lord.
Please.
Para 44,
315.
315. The petitioners have also questioned the advertisement dated 17/11/2011 for recruitment of 16 posts of Deputy Director, Inspector of School, Deputy District Elementary Education Officer of being ambiguous, vague, and self-contradictory. So according to the petitioner, my lord, the advertisement itself is vague, but he nevertheless participated. According to the petitioner, some ambiguous requirement of experience has led to opening of a plethora of forgery and manipulation of experience certificates, since most of the selected candidates do not have any teaching experience of 10 years as required for the said post. The petitioners, by filing additional affidavits, have brought on record certain additional facts indicating alleged forged and fake certificate regarding teaching experience in respect of the respondents. Though learned counsel for the respondents have strenuously argued that without amending the writ petition, the said additional facts are brought, therefore same may not be taken into consideration by this court. I am of the view that since materials have been brought on record, this court cannot shut its eye, as the document placed on record is the charge sheet filed by the CID against 6 accused persons, including 3 private respondents hearing. It is not in dispute that an Azahar was lodged by one Rajesh Chakraborty on 17/10/13, alleging that 6 accused persons, including the present 3 private respondents, submitted forged documents to the APSC fraudulently and deprived the complainant in getting selection in the post in question. Upon receipt of Azahar, a case was registered being CIDPS case number so-and-so under so-and-so provision. After completion of investigation, CID has laid the charge sheet on 31/12/21 before CJM Kamrup against 6 accused persons, including the present 3 private respondents under section so-and-so. Perusal of the charge sheet go to show that respondent number 4 submitted 2 certificates, 2 experience certificates from 2 different educational institutions, which are found to be fake. Lordship will kindly mark the word fake. It has got its own significance. I'll come to it. Respondent number 12 is found to have submitted fake experience certificate from one institute, and respondent number 470, that is the appellant, had submitted 3 fake certificates from different educational institutions, details of which are clearly reflected in the charge sheet. On careful consideration of the matter in its entirety, this court is of the view that although the guilt or otherwise of the private respondents would be a matter of trial, such serious allegation of submission of fake experience certificate followed by filing of charge sheet by CID cannot be easily brushed aside on technicality, as private respondents have secured selection appointment purely on the basis of said experience certificate, which in turn had deprived the genuine candidates. Thus, I am of the view that same warrants proper inquiry by the appropriate departmental authority, as it appears that the departmental authorities have ignored, rather closed their eyes for the reasons best known to them, and had made a casual, laconic approach to the said serious case, which is impermissible in law. Having observed above, it is nonetheless true, as held by the Honorable Supreme Court, that Section 173(2) of the CRPC calls upon the investigating officer to file his final report before the court. It being a report is nothing but a piece of evidence. It forms a mere opinion of the investigating officer on material collected by him. He takes note of offense and thereafter conducts an investigation to identify the offender, truth of which can only be decided by the court. Aforesaid conclusion will lead to the position that evidence of the investigating officer is not indispensable. Evidence is required for corroboration and contradiction of the other material witnesses, as is one who links and present them before the court. Having regard to the challenge of the petitioner to the advertisement in terms and conditions as well as the procedure adopted by respondent authority, other than the allegation of submission of fake experience certificate, to which has been already dealt with herein above, this court finds no substance, as petitioners have failed to show any tangible ground supported by material that the same are contrary to law. So this part is dealt against the petitioner. Having considered the submission of the learned senior counsels appearing for the private respondents, and after careful perusal of the case law relies upon by them on locus standi, this court is of the view that it is no doubt the settled position of law is that candidate having known fully participated in the selection process of its terms and conditions and thereafter challenge the said selection process on the ground that same is bad, if the result is not palatable to him or her, or after she failed, would not be permissible. A reference may be made to the case of Rekha Sharma versus State Rajasthan High Court in so-and-so, wherein Honorable Supreme Court has reiterated the said proposition. However, equally the Supreme Court in other cases has held that there is a glaring illegality on the facts and circumstances of the given case. Petitioner cannot be non-suited or she cannot be told off the gate. Regard being had to the maintainability of the present writ petition on ground of existence of disputed questions of fact, in the facts of the present case, I am of the view there is no absolute bar to entertain writ petition, as relevant consideration to such proposition is to the effect that whether in a given case fact is so disputed which requires taking of evidence to establish the case. In the present case, the facts are not disputed. An allegation of submission of fake experience certificate to secure appointment are previously established on bare perusal of the charge sheet. Thus, it would not be appropriate to non-suit the petitioners, and hence writ petitions are maintainable. However, as the charge sheet being a report is nothing but a piece of evidence, and it forms a mere opinion of the investigating officer on the materials collected by him, truth of which can only be decided by trial court after full trial, it would not be appropriate to interfere with the selection and
Mr.
appointment of the
Chaudhary,
private.
you are agree with it, which part?
My lord, I am agree.
Causing an inquiry, we are,
Yes.
you are aggrieved.
Yes, fine. Now, my humble submission is very simple. Number one, in the original writ petition, there is not a single sentence attributing any wrongdoing to the appellant before your lordship. Number one. Number two, my lord, now writ petition was filed in 2012. Was it within anybody's contemplation that in the year 2023, a criminal case, there will be charge sheet, therefore the writ petition has to be entertained? My lord, writ petition was filed basically challenging the advertisement. My lord, I'm not saying it's an open and shut case, my lord. It's a case, I think, where lordship will have to, give finding on certain aspects. Number two. So thirdly, my lord, a charge sheet can be relied upon in a proceedings under Article 226 or Article 32 only when, my lord, it is admissible in evidence as per the Evidence Act. My lord, lordship knows that Agalpur blindings case, which is popularly known as that, my lord, Khatri, where the Supreme Court says, my lord, a charge sheet or any police report can be relied upon in a 226 proceeding or an Article 32 proceeding only when the same is admissible in evidence and as per the Evidence Act. Well, at end of the day, what is it? It's a mere opinion of the investigating officer.
Yes, Learned Single Judge has taken care of those things.
Yes.
That's a mere piece of evidence.
Yes.
It will it cannot be held to be conclusive.
Therefore, my lord, why an inquest? After I'm serving from 2012. 12. After 12 years, an inquiry has been, that too instance of a person was unsuccessful. Now, my lord will kindly see.
But that was brought to the knowledge of the notice of the court by an additional affidavit. You may be
No, my
correct.
lord,
In
what I'm-
2012, these things were not
No,
there,
my lord,
but
what I'm saying
2023.
is-
Yes.
The only the learned single judge has relied heavily on the charge sheet. This is very clear. Now, my humble submission is, my lord, this charge sheet could not have been taken note of.
No, the whole this charge sheet,
So, this charge sheet is nothing.
the
No, my lord, now,
direction to make an inquiry is an independent direction.
my lord, what are the
And that is done
materials?
by the department.
No, what are the materials for which an inquiry will be ordered? Please come to page 174.
174.
Yes. Who is this Chakraborty fellow, my lord? Who is this person who has filed the FIR? Who is this person, my lord, who has filed this RTI application?
174?
Yes,
No, not 170.
174 annexure E, my lord.
This is not by Chokro. This is some,
No, Hemanto Hazarika.
yes.
Now kindly see, my lord, the RTI applicant is the Chakraborty, one who filed the FIR.
Where do we get?
Please come to 174, my lord.
And this is
This is the RTI information.
where is the FIR?
1 second. Before that, if your lordship would kindly come to 174. These are the materials, my lord. Kindly see how it can inspire any confidence. Page 174. With reference to the subject cited above.
No, kindly show us the this thing, FIR
Yes.
by the Chakraborty.
219, my lord.
219.
নামটো থাকিব নহয় No, 220, my lord.
This is final.
Kindly see, my lord, on top. Complainant Rajesh Chakraborty.
Yes.
Who is he, my lord? Nobody knows. Now, recently, my lord, one gentleman called Dulal Bora, he has been arrested in Delhi. Rajesh Chakraborty. But this was the gentleman, my lord. He is a man from Karimganj,
Hailakandi.
Hailakandi. Now, please come to, my lord, for a moment, 174. The learned single judge takes note of a fact of a fake certificate. Now, does a cancellation of a certificate entails or it attains the status of a fake, my lord? Kindly see. With reference to the subject cited above, I have the honor to inform you that experience certificate issued to you, white number mentioned in reference above for period so and so, is duly countersigned by the Assistant Inspector of School is hereby cancelled with an intimation to the concerned Assistant Inspector of School.
Is your services, has it been disturbed?
No, man. Not. But this inquiry has the potential, danger of, my lord, upsetting everything. My lord, my only humble submission is, when you file the writ petition, you never allege any allegation against. It is after 12 years of the pendency of the writ petition that based on this Rajesh Chakraborty's application, my lord, be it RTI information or be it, my lord, the criminal case has ended in an charge sheet. Now that's why, my lord, withdrawing the challenge in respect of the other respondent, during the course of hearing, the petitioner, my lord, confined the challenge to the 3 persons named in the charge sheet. Others, my lord, they are now jolly well, they are going on. Whereas in the original writ petition, there is no allegation against me. Now, my lord, my humble submission is, a writ court is not supposed to make a roving inquiry. To do a roving inquiry, there must be foundation in the writ petition. What was that foundation, my lord?
But has the court done any reviewing inquiry?
Yes, my lord, that's why they have directed. Now, question is whether this could have been taken note of.
That point you have said.
Yes, my lord. Now, please come to 175.
Yes.
Kindly see, my lord. Now the assistant inspector of school says, writes to the headmaster, with reference to the above, I would like to state that on your report as cited above, counter signature of acceptance certificate in the name of Arup Kumar Das is hereby withdrawn. So, my lord, it is one thing to say a certificate is cancelled, and it is quite another thing to say that it is a fake. For some reason, it has been cancelled. And that too behind my back, my lord, without giving me any notice. Page 176. With reference to the subject cited above, I have the honor to state that an experience certificate was issued in the name of Arup Kumar Das, so and so, as
But
an assistant
this is
teacher.
of 2011. Yes, it has
Yes.
not been marked to you.
Yes.
But the advertisement is of 2011, where you had, it appears that you had utilized this certificate.
Yes. But I was given only 2 marks, my lord, for this. Even if this 2 mark goes, nothing happens to me. Only 2 marks I was given for experience. I still maintain my position, my lord. And moreover, I am scheduled, my lord, both the petitioners are OBC and MOBC, and I am a scheduled caste candidate. So, my lord, no, my lord, therefore, taking a totality of the facts and circumstances, number one, in the writ petition, no allegation. Number two, what was challenged was the advertisement. Number three, you have participated in the selection process. Number four, my lord, the charge sheet was the only document based on which, my lord, the learned single judge has taken note of the matter seriously. Now, if your lordship would kindly have the judgment, I cut the judgment. My lord will kindly have this Bihar Bhagalpur case. Marking huh? No copy to give. So kindly, my copy has been displaced.
You take a copy?
No, my lord. I have the copy where I have normally keep the. Yes. Please come to page 501, lord.
Of Khatri judgment?
Yes.
Yes.
After section 172 is quoted, my lord. The criminal code holding an inquiry or trial of a case is therefore empowered by subsection 2 of section 172 to send for the police diary of the case, and the criminal court can use such diary not as evidence in the case, but to aid it in such inquiry or trial. But by reason of subsection 3 of section 172, merely because the case diary is referred to by the criminal court, neither the accused or his agents are entitled to call for such diary, or they are entitled to see it. If, however, the case diary is used by the police officer who has made it to refresh his memory, or if the criminal code uses for the purpose of contradicting such officers in the inquiry or trial, the provision of 161 or 145, as the case may be, of the Indian Evidence Act would apply, and the accused would be entitled to see the particular entry in the case diary which has been referred to for either side. So, first, if I kindly skip this portion, kindly come to the sentence. This bar can obviously has a lordship. This bar can obviously have no application where a case that is sought to be produced and used in evidence in a civil proceeding or in a proceeding under Article 32 or 226 of the Constitution of India, and particularly when the party calling for the case that is neither an accused nor his agent in respect of the offense to which the case diary relates. Now, plainly and unquestionably, the present writ petition has been filed under Article 32 of the Constitution to enforce the fundamental right guaranteed under Article 21 is neither an inquiry nor a trial for an offense, nor is in this court hearing the writ petition a criminal court, nor are the petitioners accused or the agents so far as the offense arising out of their by blinding are concerned. Therefore, even if the report submitted by L.V. Singh as a result of his investigation could be said to form a part of the case diary, it is difficult to see how their production and use in the present writ petition under Article 32 of the Constitution could be said to be barred under Section 172. Then Lordship may kindly skip that. Sufficient. Not 29, not. I'm very sorry, Milord. My copy, which I normally mark, that is not brought. That's a big judgment. Kindly bear with me for 2 minutes, Milord. I'll just find out.
On what aspect you want to?
Milord, that in a proceeding under Article 32 and 226, it cannot be used unless it is relevant in other words, Milord, since while taking note of this, and nobody was put to any cross examination, therefore this cannot be taken note of. Very sorry, Milord. 1 second. Yes, please come to para 7, Milord. Page number 50T, 503. That takes us, that takes us to the question whether the report made by L.V. Singh as a result of investigation carried on by him and his associates are relevant under the provisions of the Indian Evidence Act so as to be liable to be produced or received in evidence. It is necessary in order to answer this question to consider what is the nature of the proceeding before us and what are the issues which arise in it. The proceeding in a writ petition under Article 32 for enforcing the fundamental right of the petitioner enshrined in Article 21. The petitioners complain that after arrest while under police custody, they were blinded by the members of the police force, acting not in their private capacity, but as police officials and their fundamental right to guarantee a life guaranteed under Article 32 was therefore violated. And for this violation, the state is liable to pay compensation to them. The learned Attorney General, who at one stage appeared on behalf of the state, and the hearing of the writ petition contended that the inquiry upon which the court was embarking in order to find out whether or not the petitioners are blinded police officers while in police custody was irrelevant, since in his submission, even if petitioners are so blinded, state was not liable to pay compensation to the petitioner. Firstly, because the state was not liable to pay compensation to the petitioner. First, the state was not constitutionally or legally responsible for the acts of the police officers outside the scope of their power of authority, and the blinding of the under trial prisoners affected by the police could not therefore be said to constitute. This was the contention of the learned Attorney General. Then my lord may kindly skip the then.
You're finding an exception to them.
Yes, my lord.
The Chaudhary is always on our fingertips. Today you're looking for the person.
Oh, my lord, the difficulty is, my lord, my junior has put in a fresh copy.
Mark paragraph.
Yes. No, give me that.
Okay, we have.
No, my lord, the proposition is.
You've got the proposition.
Proposition is, my lord, in a 226 proceeding or a proceeding under Article 32, this cannot be used. The reason is very simple, because of Section 33 of the Evidence Act. If a lordship will kindly have Section 33 on Evidence Act. Please come to Section 33, my lord.
Evidence Act.
Page Section 33, my lord.
Relevancy.
Please come to the second proviso, my lord. That the proceeding was between that the adverse party in the first proceeding had the right and opportunity to cross-examine. So, my lord, this was an information which was gathered by the IO, based on which charge sheet has been filed. Now, that is only a prima facie finding. So, in a 226 proceeding, only that information would be admissible, which is otherwise valid in terms of evidence. And that is only one version. Therefore, in a 226 proceeding, it cannot be, relevant. Now, if that is the position, my lord, how does the learned single just take note of the charge sheet to come to the conclusion that it calls for an inquiry? That's the point. In my humble submission, my lord, this could not have formed basis. This cannot constitute material to invoke the power under 226 to direct an inquiry. That is the only thing. And the learned single judge refers to that judgment also, my lord. And in my humble submission, my lord, learned single judge takes note of the implications correctly. But when it coming to, my lord, taking note of that aspect, my lord, the relevant consideration was ignored.
But 33, the relevancy is only in a subsequent proceeding.
Yes.
In one proceeding,
Yes.
either the witness is dead or cannot be found. It is only in a subsequent proceeding.
No, my lord, what I'm trying to impress for your lordship's kind consideration. When a charge sheet is filed, compliance of section 33 is not done.
33
Because the
may-
other side is,
33 may not be applicable.
no, what I'm saying is, my lord, this judgment is an authority for the proposition that same material cannot be used in a 226 or a 32. The charge sheet, my lord, it is nothing, my lord, this cannot be
The
taken.
single
note of.
judge has, whatever you're submitting,
Yes.
single judge has in fact held that it's still in the realm of evidence.
Yes,
It is a piece of document which has to be proved in the court
Yes.
of law.
Hmm.
But he noticing the materials on record, he says that do an inquiry.
I'm
What is
sorry, Mila, I got it. Please come to para 5. I got it.
Paragraph 5.
Yes.
Paragraph 5 we have read.
No, para 3, my lord. Yes, I'm so sorry, I got it.
Paragraph 3.
Para 3, yes.
Please.
Para 3 starts at page 497. The problem was I was charging in the later part. Please come to page number 498.
Yes, please.
Now, my lord, this court in Tahsildar Singh, as a lordship got it, yes. This court in Tahsildar Singh's case approved the following observation of Broad J in so-and-so versus so-and-so and expressed its agreement with the view taken by the division bench of the Nagpur High Court in Baliram Tikaram Marathe versus Emperor that object of this section is to protect the accused both against overzealous police officer and untruthful witnesses. Protection against use of statement made before the police during investigation is therefore granted to the accused by providing such statement shall not be allowed to be used except for the limited purpose set out in the proviso to this section at any inquiry or trial in respect of the offence which was under investigation at the time when such statement was made. But this protection is unnecessary in any proceedings other than an inquiry or trial in respect of the offence under investigation. Hence, the bar created by this section is limited bar. Now, kindly see. It has no application, for example, in a civil proceeding or a proceeding under Article 32 or 226 of the Constitution, and a statement made before a police officer in course of investigation can be used as evidence in such a proceeding, provided it is otherwise relevant under the Indian Evidence Act. There are a number of decisions of the various high courts which have taken this view, and amongst other issues. I was not relying on this passage. So they cannot take note of. So, my lord, only material on which the learned single judge places reliance is the charge sheet. Charge sheet is nothing but an outcome of an police investigation. So this is the sentence part. Actually, I was looking towards the later part. It has no application, for example, in a civil proceeding or a proceeding under Article 32 or 226, and a statement made before a police officer in course of investigation can be used as evidence in such a proceeding, provided it is otherwise relevant under the Indian Evidence. So this is I am resting my entire case on this. Therefore, in my humble submission, my lord, it is not a case where the learned single judge could have directed the inquiry because there are no material. And my lord, this is not a fake. All that they say, they have cancelled it. Well, I'll just show the marking position. I was given only 2 marks. Even otherwise. Marking to what is that? Is 2143. 216. If your lordship would kindly come to page 210. No, no. 210. Yes. My lord. This is the statement showing marks given to all the candidates. Serial number 14 is the appellant. In experience, he got only 2 marks. Page number 210. Serial number 14.
Anup Kumar Das.
Yes.
So that is only almost uniform for all. That
Yes.
is the maximum.
Therefore, my humble submission is, my lord, the only material, and my lord, what about this doctrine of election part, my lord? Can he say now that no, I'll only confine my challenge to these three?
These are the selected candidates.
Yes. And in the writ petition, he alleges allegation against everybody except the appellant. Now, my lord, he is confining to the only appellant and two others because there is a charge. So, my lord, on the day when he filed the writ petition, what was his case? His case was not that I have submitted a course certificate or something. So, what was that foundation, my lord, enabling the court to give this direction? Only foundation is the charge sheet. Charge sheet, as I have already submitted, could not have been used, my lord. Therefore, it's a matter which is examination. And before eventually subjecting me to an inquiry, I think that aspect of the matter will have to be decided. Whether in such a situation, an inquiry can be directed. So that is my humble submission. My lord, regarding roving inquiry, those judgments, our High Court judgment is there, my lord. That's Sadananda Haloi. And my lord, they have participated with eyes open. And I think it is too harsh, my lord. Rather, the action proposed is too disproportionate. After serving for 12 years, end of the day, my lord, the test of proportionality will come everywhere. Not only in matters of awarding punishment, even an action proposed, if it is disproportionate, my lord, this order can be used in any manner. It can lead to anything. And my lord, who is this fellow called Chakraborty? Nobody knows. And his identity, nobody knows, my lord. That is my humble
Okay.
First, I will point out that they have made respondents on 5 to 13. Their names were withdrawn, but yet they have been made respondents. Not can get an order. This petition itself is defective. Right? This document is petition. The private respondent name has been withdrawn. Struck off. They made it. They be made part. This one and page 62 euro. Page 62.
Just a minute.
Petition itself is defective.
Appeal is defective.
Page 62 euro. Page 62 euro. Can the advertisement issued?
Yes.
Advertisement issued
Yes.
and page 63, my lord, your lord.
Hmm.
This is the number 2, serial number 2, 16 post of deputy director, inspector, etc. So,
Yes.
District elementary education, etc. So they have got it.
Yes.
The educational qualification, second class master degree having uniform brilliant career and possessing teaching experience in school or college for 10 years or administrative experience for 10 years, of which 5 years must be in teaching. This is in consonance with Rule 5, Rule 3 of the Assam Education Rule to 1982.
Hmm.
So Lordship will get it at Schedule 2, page 713 of this book. This is in consonance with Rule. So if you do not have 10 years experience, even if after 10 years I come here saying that the person who got the appointment on the basis of the fake certificate, court will interfere. Authority will inquire into the matter. Now they are saying that we have not said anything against them. We brought the allegation in the form of an additional affidavit where they have not filed any reply. Page 120. The relevant is page 174. Page 170.
170,
174.
174.
It is part of the additional affidavit where they have not filed reply. Has your lordship good? 174. This is a letter to by the headmaster saying that with reference to the subject that I have the honor to inform you that the experience certificate issued to you mentioned in the reference above at the period from 2002 to 2010 is duly countersigned by Assistant Inspector of School is hereby cancelled with an intimation to the concerned Assistant Inspector of School. There is a further the countersign also withdrawn. Now next page, your lordship will kindly see page 175. With reference to the by the Assistant Inspector of School to the headmaster. With reference to this reference to the above, I would like to state that on your report, as cited above, the counter signature of experience certificate in the name of Sri Anup Kumar Das is hereby withdrawn, and you are directed to ensure that the experience certificate shall not be allowed to be used by Anup Kumar Das under any circumstances failing which he will be held personally responsible as per law. Now next page. My lord, this is by the headmaster to the Assistant Inspector of School. With reference to the subject cited above, I have the honor to state that an experience certificate was issued in the name of Anup Kumar Das, so and so, with effect from September 2002 to April 2010 by number so and so, which was countersigned by you on so and so. In this regard, I submit that the certificate was wrongly issued by the undersigned, so the certificate is hereby cancelled with immediate effect. Now 77, with reference to by the headmaster to the to one Rajesh Chakraborty who has sought information from the school and who has also filed writ petition and subsequently the FIR. With reference to the subject cited above, I would like to inform you that no person named Anup Kumar Das had served in the school as assistant teacher. The experience certificate issued in the name of Anup Kumar Das covering period from 2002 to 2010 was misconceived, which was already cancelled. Now, next page, 178, head teacher says, my lord, he did not work. With reference to the subject cited, subject mentioned above, I want your clarification regarding issuing of the experience certificate in the name of so-and-so, 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 covering period 2002 to 2010, which he submitted along with his application for the post of so-and-so within a stipulated time. So therefore, and this was the certificate issued, my lord, page 179. This is the certificate issued. And next page is that 2-year certificate. So these are the certificate issued with the documents of experience. If your experience certificate is found to be false, here, my lord, I have given sufficient material along with them, my lord, what has been found in the charge sheet to show that the certificate has been, which has been used by the appellant is on the face of it, it's not correct, I would say, and it is a fake certificate. So court has directed you inquire into the matter. Now, charge sheet, my lord, relevant page, your lordship will get it at page 242. 242. Court has not taken anything into, finality, but 242, my lord, it is not clear, but I can read it, my lord. 2. FIR named accused Anup Kumar Das had submitted 3 fake experience certificates, which were shown to have been issued from 3 different educational institutions. The following facts were unearthed during the investigations against the state accused person. So details are there, and they have discussed all the documents which I have stated before you. Now, impugned judgment also, this matter has been discussed at page 297. Okay.
Yes.
Page paragraph 17. The head teacher of so-and-so school had cancelled the experience certificate issued to paragraph 17, issued to the respondent number 17 for the period 2002 to 2010. The head teacher stated that the Anup Kumar Das did not work in the school If the certificate, with a false certificate, if somebody works, that his employment is liable to be cancelled. That's the Supreme Court judgment. I'll just raise. So this is also discussed. Additional affidavit, my lord, they have not filed reply. What they will have to file, my lord, if they say, my lord, the head teacher has said that the certificate is false, they will have to bring additional documents to show that the certificate is correct. I have, my experience certificate is correct. With a false experience certificate, if somebody works, even after 20 years, if I come to know caste certificate or any fake experience certificate, court will definitely order the inquiry. And if the inquiry proceedings, they find something different, here sufficient materials are there. I'm just raising two judgments, three judgments. The Lordship will kindly see for the timing, flag B. They don't want that this matter should be inquired in. How can a person be allowed to work, my lord, get entry into the service with fake certificate? Paragraph B, my lord, your flag B, paragraph 31, your lordship will kindly see 40 times. Yeah.
Punjab and Haryana.
Yeah, Punjab and Haryana, it is based on Supreme Court judgment.
Show the Supreme Court.
Hello?
Please place the Supreme Court judgment.
Yes, Supreme Court judgment. Sir. Hello, 2008 Code SCC, that is regarding caste certificate.
The first one, flag A.
Yeah. Paragraph 2, 5, 6, and 8. That is on reservation. I have given a small note also on the matter.
No, note is not, it's not only a paragraph numbers.
Yes, paragraph number.
4 SCC 612. What does the Dattare says? What is the ratio in Dattare?
Flag A, my lord.
Yes.
Flag A is, my lord, it is on the basis of
Paragraph?
paragraph 2 and 5, 6, and 8. That is on caste certificate.
Now, how is it relevant?
Even if caste certificate, if it is false caste certificate, it can be inquired into the service can be terminated. Second is, my lord, requisite qualification in the form of experience. This is relevant in similar to our case, my lord.
Which one? The Punjab case?
Yes. High Court of Punjab and Haryana. Paragraph 32 to 34, my lord, Supreme Court discussed. Like B, my lord. Discussed. Wherein the Honorable Supreme Court held that selection.
Paragraph?
Yes.
Paragraph 30?
31, 32 to 34. Apex Court discussed, my lord, wherein the Honorable Supreme Court held that selection of an employee was conceived in deceit. The same could not be saved by equitable consideration. Even delay in verification of such document, 20 years delay will not validate the certificate. Employee had worked on a fake certificate for a period of 20 years. Honorable Supreme Court opined that sympathy have no place where appointments rest on a fake certificate. Paragraph 2015-11 SCC flag C, my lord. Paragraph 2, 3, 4 and 5.
Hmm, 2000?
2015-11 SCC 355 flag C.
What's the flexi अपना? No flexi नहीं.
That is not keep copy.
There is no flexi here.
Exit here. Not- Last copy. Or probably the flag is.
No, no, that compilation is not there. Only two judgments are there.
Two judgments. So I'll provide. Alert.
Paragraph?
Paragraph. Alert, 2, 3, 4 and 5. I'm sorry, my lord, I have not provided.
Paragraph?
answer. The lordship has got
Yes, yes, I.
Para?
para 2, 3, 4 and 5. Obtain appointment by using fourth token. Is liable to be cancelled. So therefore, when the learned single judge based on this material directed for an inquiry, my lord, your lordship will ask them to complete the inquiry within a shorter time. Learned single judge directed consideration of our case because I'm just below them. We're getting equal marks. Excepting one position number 1 has withdrawn. I have shown, my lord, the validity of this survives when the case has been filed within time. 2012 maybe. Well, I have shown the court judgment saying that if I come under the zone, my lord, then our case should also be considered. And other cases, my lord, other respondents have been withdrawn by we have track of their we have withdrawn against them because against them, my lord, the allegations were age condonation and not through proper channel. And so I do not find any anything against them in the charge sheet. So whatever material was there before the in the read petition and the charge sheet. So against 3 persons we found. So we have said that 3 persons may be retained, others may not be. So accordingly, the others were struck off. So on the face of it, my lord, I would humbly submit, my lord, the learned single judge has passed the order in the interest of justice for the purpose of inquiring into the matter, of finding out the truth.
Was there an observation that the select list will remain valid?
No, there is no like that. But
At the time, you said at the time of moving, you had approached the court in time.
within time,
So you are seeking a claim that since your name is just below the names of the petitioners, I mean the private respondents.
zone of consideration, if I come within, it can be considered. I have placed one judgment that, my lord, but now. But inquiry should be completed. This is a very serious matter, my lord. Person entering, my lord, service with false appointment letter, the allegation itself with material support. It has to be inquired by the authority.
Yes, department.
I'm deeply obliged.
Allegations which were brought on record in the writ petition.
In my view.
The allegations which have been brought against the appellant.
Hmm.
The allegations are there in the charge sheet. One was the fake certificate. Said that the facts and they were not correct. The experience part is not correct. But the signatures are of the person who said he had. One certificate is one where the person says that I never issued it. Forensic says that it was never issued by the person. So that was the forged certificate. And the third was where one of the witnesses said that I have erroneously issued the certificate. I am recalling. So there were 3. Now, if we see the observation of the learned single judgment, one observation. Yes. Page 316, paragraph 48.
316
16 of the writ appeal.
paragraph 48,
Yes.
seventh line from the top, my lord, starts with the word which in turn has deprived genuine credit. At paragraph 48, seventh line from the top, starts with the word which in turn. First line,
Paragraph 48.
my lord. Seventh line from the top starts with the word which in turn.
48 is on perusal, on careful consideration.
Consideration, my lord, seventh line from there.
Seventh
If
line.
there is one, yes, my lord, if there's line one, one,
Three,
two,
four,
three, four,
five,
five,
six,
six,
seven.
seven, eight. I'm
Does.
sorry, eight.
8.
On careful is first line, then due matter certificate brush selection which. The first word. Or in the middle, my lord, thus I am of the view that same one.
Read it.
My lord, I
Yes,
read. On
yes.
careful consideration of the matters in its entirety, this court.
No, that does. You're reading from the does. Does I am of the view.
Yes, my lord. Thus, I am of the view that same warrants proper inquiry by the appropriate departmental authority as it appears that the departmental authorities have ignored, rather closed their eyes for reasons best known to them, and had made a casual and laconic approach to such a serious case. Then, my lord, the directions at page 319, paragraph 55. Accordingly, it is directed that the Commissioner, Department of Education, Government of Assam shall cause an inquiry into the matter and pass consequential order.
Paragraph
55, madam, page 390.
Yes.
Well, the inquiry has been directed because there was an impression that despite having knowledge of some illegalities coming into court, there was a criminal case. Department must have been in, someone must have. But we closed our eyes and therefore put with it, there should be a direction for us to come to an inquiry. But even if we accept the argument that an inquiry could not have been directed, there should not be any impediment on us to hold an inquiry if we so deem fit. So the direction to hold an inquiry is because we kept sleeping on the matter. Otherwise, if we now want to hold an inquiry, my only prayer is, my lord, he should not be able to take a handle that the honorable court has directed not to. That holding of an inquiry or otherwise, apart from the criminal case, on the facts that these were certificates which were issued by schools, which perhaps are under our control, or perhaps which we can have access, that would be the probability, preponderance of probability, my lord, which yet be allowed to go into. Because there is an allegation that certificates were taken, the advertisement and the rules say that that experience is an integral part of the recruitment process for the selection of a candidate for that. So it will hit at the very root of the appointment. Therefore, whether it is a direction or a liberty, we should not be barred from holding an inquiry. Since it has come to notice that there are things that otherwise might be just property.
What about the direction for consideration of his case?
But the consideration of this case, there I would say, he did not make it on merit at that point of time. If someone now goes, it will be like dismissing or terminating or cancellation of the candidate. Now someone cannot say that I was there somewhere, so now taking up. That will never be. That will be a post which goes vacant. We fill it up by regulars. It would not be a case where he comes. That cannot be the. In my humble submission, that
even
is
if a candidate doesn't join, it will be treated as a new post.
Yes, it goes a vacant post on that selection.
Now
Nothing
after-
happened.
And now it's on a very premature stage. What you find in the inquiry?
We do not know.
if
We may find it is correct. We may find it is not.
If
It
you
is not
oppose
valuable.
that everything is okay.
Or there might have been other documents which give him that leverage so that yes, even ignoring them, we can have. There may be so many. But at this stage, two things, my lord, we cannot be debarred from holding an inquiry, be it as a direction from this honorable court or be it as a liberty from this honorable court. And secondly, my lord, posts will not be picked up by persons who were then participating in the post. Apply.
Well, I'll just give a 5 minutes reply.
Yes.
If your lordship would kindly come to page number 32, my lord. That is where the repetition starts. Please come to page 48. Page 48, para 8.
48.
Yes. Lordships will not permit the petitioners to blank fire, my lord. If they knows the target, then they should hit it or else not.
48, yes.
Page 48, that
Par-
it is to be noted that in the-
Paragraph 8, you are.
para 8, para 8. It is a writ petition bill. That it is to be noted that in the list of candidate as posted in APSC website, after scrutiny showing particulars of candidates and status of their applications, the application of now one Chinmoy Talukdar, then 3-4 lines below, my lord, Shubha Lakshmi Rajkumari, and if your lordship kindly comes down below, para 9, Anjan Kumar Dekha, then if your lordship would kindly come to page 50, para 10, Jayanto Thakuria,
Yes.
then my lord, para 11, Buli Gogoi Bhuya. So he had specific, averment. Then at page 51, third line, my lord, Samina Ara Rahman, respondent number 12. No allegation against the writ petition, appellant. Now, would your lordships permit, even without the basic pleadings, that an inquiry should be against me? End of the day, my lord, robbing inquiry, the concept is what, my lord, that if you want to allege something, at least you must lay some foundation. That I am alleging so-and-so against so-and-so. There's nothing, my lord, in the writ petition. Now, please come to the additional affidavit, which, based on which, my lord, the learned single judge now takes note of it. Please come to, my lord, page 130.
130.
Yes. How, my lord, they misled this honorable court, page 130. He is a petitioner. My lord will kindly take note of that. Para 10, page 130.
This is an additional affidavit.
Yes, my lord. This is what was taken note of by the learned Singh.
It starts where?
It starts at page 120. I'll have your lordship's kind attention to page 130.
Yes.
That respondent number 17, that is the appellant, Anup Kumar Das, submitted an experience certificate for the period so-and-so to so-and-so from Tiwanagar High School, Narakakhur Pahar, Guwahati 19, but in response to an RTI application, the headmaster of the aforesaid school, Hemanto Kumar Hazarika, by communication dated 3/8/13, informed the applicant. Now, who is this applicant, my lord? He is knocking the doors of an equitable court. He is not coming up with facts. As if, my lord, he was the applicant. That's the impression. That Anup Kumar Das never served so-and-so, and experience certificate was wrongly issued, not fake, which has therefore been cancelled on so-and-so, and the cancellation order was immediately communicated to so-and-so. But was it not incumbent on the part of the petitioner to come up, my lord, with the candid disclosure of facts? That one so-and-so Chakraborty from Hailakandi, he filed an RTA application. From the RTA application, it so transferred. Where are those statements, my lord? On the contrary, if we go by the purport of para 10, as if, my lord, the petitioner has filed the RTA application, and on the basis of that, this information has he come up with clean hands? Now, my lord, these are the conduct. Now, end of the day, my lord, I will reiterate my submission. In view of the decision of the Supreme Court in Khatri, my lord, this charge sheet would not form a material for invoking the jurisdiction under Article 10, because it is not an evidence within the meaning of evidence. Yes, it's a case of trial, etc. In a civil proceeding, in a 220 proceeding, this charge sheet has no meaning. This cannot form a material. It cannot form the foundation for any act. So therefore, my humble submission is that the impugned directions are without jurisdiction, without. Rather, it is against the settled principle of law. The learned single judge should have considered this. Lord, and that to me, Lord, after 12 years, I would respectfully submit. This was an exercise of jurisdiction, which was rather disproportionate. And even if this 2 mark is given, my lord, erase, my lord, no difference takes place. And my lord, my friend Mr. Majumdar, he has virtually supported the writ petitioner, my lord. But in any case, it is their selection. But that being the position, my lord, I think here is a matter where Lordship will give due considerations to this submission. End of the day, my lord, these are all legal stuff. Maybe technical, but nevertheless, these are legal. That is my opinion.
Okay, we'll pass the order day after tomorrow probably, or before the vacation.
Miller.
Okay, reserve for orders.
Deep problem.
Tomorrow naam likhiba, huh? Vididas. And Mr. Chaudhary, what about the other cases? Same.
Here he is respondent number 4. Here it is respondent number 70.
There are 2 writ appeals. Other case. And what is the allegation?
Same, Miller.
No. In fact, that better. Don't think that.
But there, my lord, the not on the basis of the allegation in the charge sheet, otherwise.
Now, what is the allegation otherwise?
That false certificate.
False certificate.
Experience.
Experience. Even the certificate, the person who has given the certificate, that doesn't say it is false. They said we have cancelled it.
Okay. Yes. ठीक है। Mr. Das, you are for which matter? You are the writ petitioner. No, you are the writ petitioner. And in both the matters, you are the writ petitioner.
No, in one of the matter, your lordship, the writ petitioner's counsel has not appeared. They are on caveat. My respected senior is on caveat. In item number 20, my respected senior is appearing for, I'll just say, my respected senior is appearing for respondent number 1, 2, and 3.
Madam Deka, please give a list where you are appearing. In which case there are two matters, item number 19 and item number 20.
In item number 19, notice should go, your lordship, because nobody is appearing on caveat. In item number 20, the writ petitioners before the learned single judge are appearing on caveat. That is my respected senior. Respondent number 1 and 2. 1, 2, 3, they say they are not appearing because he has withdrawn. 1 and 2.
Oh, he is. No, appellant is the same. Apparent is the same. Writ petitioner bileg asile. Mr. Das, you are in which matter?
Item number 20.
20 for the writ petitioner.
Yes,
And 19, nobody has appeared for the writ petition.
nobody.
It is the first time it has come.
Yes, sir.
Regarding? But it will go against the FR what?
That direct,
Financial management rules,
that direct.
FRBM. FRBM has made the position entirely different 2006 onwards. No, 2006,
Was there.
4 or so, I think 2005.
5.
2005. FRBM will
I see.
kindly place it.
Your lordship, my.
Yes.
Your lordship, my respected senior appearing for the appellant has relied on 2 judgments. One is Sadanand Halloy and one doctrine of elected. May I please those judgment of, if your lordship.
No, we have Sadananda Halloy, not Halloy, Halloy,
Hello, yes, your lordship.
not required. Okay. Take. যদি examination এর কারণে পাওয়া যেতে হয় তো শুনানি করার দরকার নাই, এটা হচ্ছে। Who's 5? দেখি স্যার। Both the cases, okay. No role of the APSC. Yes.
Deeply obliged.
Lordship will take it up after 5 minutes. Miss S.H. Bora has looked into the matter.
9 is for what?
This I is
There is an
pressing.
I, my lord,
I for
For
suspension of sentence,
conviction under
21 B2C, the commercial quantity, under
NDPS.
NDPS Act.
He has filed the written object. He'll know the facts.
Okay. Wait for a while.
Okay.
A judgment of which year?
My lord, 2023.
Rajan Hardin, no.
Pradeep Primary,
Commercial quantity.
commercial quantity.
May not be inclined. What are your grounds?
My lord, on the basis of evidences, my lord, there are 2 accused, my lord. One is this appellant, that is Rajiv Primary, and other is one
See,
Firoz.
suspension of sentence, if you are going to the merits, you would like.
No, my lord,
prefer to
I'll
hear-
point out just 2, 3 major points, my lord. Because from the evidence, it is not clear who was actually arrested on the spot. Because the police says that it is this appellant, whereas the independent witnesses, they said that it is the other accused. But according to police, on the date of incident, the other accused fled away. So the independent witness says that he was arrested. And further, he was not produced within 24 hours and not along with the ganja before the policeman. And they have also failed to
establish the link evidences, my lord. These 2-3 major points, my lord.
This would, these are absolutely on the merits. Better we'll prefer to hear on the entire appeal. Has the paper book been prepared? LCR has come or not?
LCR is
LCR
here.
has come.
LCR is here. The office. No, LCR is not.
LCR is in.
Here. Ah, not there.
Sonitpur.
There is an office.
Records called for. Already been transmitted to the High Court. Same mistake. Yes, there is another 406. What is that?
My lord,
Criminal appeal 406. By whom? There are two accused persons. How many accused persons are
2
there?
accused persons.
One has already preferred 406. LCR has been already sent in connection with that.
Oh, both can be tagged together.
We'll have, today will not pass any orders, neither, let us first see what has happened in that case.
Other.
Okay, you are not appearing in the other case?
No, no, my lord.
Okay. Office note dated 27/9/2024 reflects that the LCR has been transmitted in connection with another case, criminal appeal 406 of 2023. Full stop. List this case, list this appeal along with criminal appeal 406 2023 immediately after the vacation.
All right.
406 is by whom? Any idea,
Lordship?
madam?
Hmm?
Bora?
What?
Have you seen the office note? There is another appeal 406 and
Yes.
LCR has been transmitted in connection with that appeal.
Not.
We have not said anything,
Both the
but we are
merits
more
will be
inclined
checked
to
together.
hear on the merits. Because he's pressing on the merits.
Sure.
He's trying to make out some valid points.
Sure.
Let's see. Today we have not expressed anything. We'll see what has happened in the other case.
Sure.
সেইটো লগত লিষ্ট কৰিব দিলা ন?
Delay, no?
May I please? The delay continuation appeal.
First time.
There is a delay of 68 days.
First time.
600?
668.
668.
And what is the conviction?
Which
Poxo
one?
matter again.
Section 6 of Oxford.
Okay, well, issue notice. Heard Sri J. Das, learned legal aid counsel.
Legal aid.
Who has
Condonation of delay is up to your lordship.
a POXO case.
POXO case.
Let notice go.
Sure.
There. Who has filed this application under Section 5 of the Limitation Act 1963 for condonation of delay of 668 days in preferring the present appeal. Full stop. The appeal has been preferred against so and so. Let notice be issued. Ms. Ad Jahan, learned APP, accepts notice for respondent number 1. Steps
Yes,
for
1.
service of notice upon the respondent number 2 be taken through the registry in the manner prescribed. Steps within 2 working days. List after 6 weeks, along with service report, by which time the respondents may file affidavit, may file objection, if so advised.
Okay.
No. 12, the council tried to take time in the morning. There is a delay of 198 days.
Yes. Will issue notice.
92 days.
Mr. Telly, you're there on record or not? No.
No.
What is your name?
P. Telly.
P. Telly. Heard Sri P. Telly, learned counsel, appearing instruction of Sri
P. Jamar.
V. Jamar for the applicant. Full stop. For the applicant who has filed, Section 5 application. For condemnation of how many days delay?
192 days.
192 days. Okay, Diba. Issue notice. As Jahan 1. 2 hole 2. Take us through the registry. Take steps within 2 working days.
supplemented.
Yes.
May present.
Medical report was called for lordship. The report is
Yes, you have got the report. Yes. What does it say?
lordship. He has gone through one voice thyroid surgery and one therapy is given to him for ENT for voice. And other is one surgery for breathing per rectum. So he was sent for that. Now he is taking medicine.
Goodness. Huh? No, surgery about to find. No, good. Where is the aspect of surgery, Mr. Counsel?
Sorry.
Where is the aspect of surgery? On the last occasion, you had said that you have to undergo
Lordship,
surgery.
The order reflect, my lord.
No, you have some medical issues, but those have been addressed. One is the voice therapy because of goiter surgery, and one is the ailment of piles for which you have been taken, you have been advised medicines.
Earlier occasion, my lord, he got operated on throat, my lord, due to just
It is not
Yes.
deteriorating. Your version is not as the same as the medical report which you had called for.
There is no such suggestion that his condition is not
Conviction under?
POCSO.
informed.
Sorry. Your name Ahmed?
Yes.
H. Ahmed.
Yes.
For?
For information.
For information.
Okay, okay. Heard Sri H. Ahmed, learned counsel for the applicant. Also heard Miss A. Begum, learned APP, Assam, as well as Miss P. Deka, learned counsel, representing the amicus curiae, appearing for the informant. Footstep para. By this application, filed under section 430 of the BNSS, the petitioner, the applicant has prayed for suspension of sentence on medical grounds. Para. On the last occasion, that is 25/9/2024, this court had directed for obtaining a report from the jail authorities
on the medical condition of the applicant, full stop. Para. The learned APP has presented a report dated 28/9/2024 issued by the Superintendent, District Jail, Borpeta, on the health status of the applicant. Full stop. The same has been produced. Full stop. The report does not suggest any serious ailment or immediate surgery, and rather it reflects that medications and speech therapy are presently undergone by the applicant. Full stop. Para. In view of the above, we are of the opinion. The conviction is under the POXO Act. Full stop. Para. Taking into consideration all the facts and circumstances and the medical report, comma, we are of the opinion that no case for suspension of sentence is made out at this stage, and accordingly, the application is dismissed.
Main appeal may be heard.
LCR has come.
Lordship, paper book is also ready.
Paper book is ready.
Lord.
Appeal of which year?
23.
The in the mail appeal you write the application number so and so for suspension of sentence has been rejected today. Full stop. Para. Since the paper book has been prepared, comma, the appeal will be listed for consideration in its turn, for hearing in its turn. In its turn, 23 matter, there are other matter also. It will come.
All right.
Second 14.
Lordship, my senior Nargis, SK Nargis and senior counsel HRA sir would be appearing for the matter. For some personal inconveniences, they could not appear today. Kindly a date may be given after break.
What is the reason you have assigned in your adjournment memo?
I gave it in, they could not prepare the matter, Lordship.
Adjournment memo which has been filed 24 hours early and you are not prepared with a case. What is this reason?
My apologies.
Can this be a reason that you cannot be prepared, 24 hours before? If you are out of station, you cannot be here, the matter will be different. But what is this? Case could not be prepared. We are not going to accept this kind of reasons. It's not that in the morning you have said that you have not prepared. You filed this one day before.
My apologies.
And this is a matter of which year? 17. Prejudice is not going to be caused to anybody else but to you. You are delaying the matter. Is there a suspension of sentence? Your form, madam?
Mr. Speaker.
Sigan.
Speaker.
SCCAL.
NCB, for NCB.
Is there a suspension of sentence?
Yes.
That is why. If he was behind the bars, he would have rushed to the court.
Court number 7. Court number 7.
Have you understood what we have asked you? Is there a suspension of sentence?
That is pending, Lord.
Should understand the consequence. What is the question, madam? Just do not appear like this. Okay. A prayer for adjournment has been made on behalf of the appellant. Para, list. Immediately after the Puja vacation.
DPO.
Sixteen. 15 to timely, sir.
May
Jet Kamara Pani. Yes, madam.
In this case, the appellant is convicted for life. Today, actually my senior argued the matter. He is engaged with the.
You will not argue.
I think the I was also rejected.
I also rejected. He is
Is inside.
imprisonment for life, my lord.
There is an eyewitness here.
I witnessed that.
Why don't you argue? Conviction of which year?
2022. It is after, immediately after back.
Next day also you are going to take time, we know.
This 302, a lady killing another lady. And one witness had seen her. cutting her neck.
Eyewitnesses is there.
Witness is also a lady.
This is the lady accused. Motive I'll have to find out, of course. I have also, yesterday she said that they will
Motive
not.
of a lady you cannot find out.
So,
Nobody will able to find
yes.
out.
Victim was going to give tea to her son, and then on the way she was killed by the this accused person.
Killed by what?
Killed by machete.
Machete?
And her neck was cut.
Okay. A prayer for adjournment has been made on behalf of Sri P. Kotoki, Learned Counsel for the appellant. Put the para list after the puja vacation.
Definitely, IA has been pending since long.
IA for sentence suspension. Paper book is there.
Paper book is ready.
Is it for hearing?
It is for. I've gone through the case and I think it's a case for bail because although in POCSO matters, the prosecuted statement is enough. If it inspires confidence and if it is consistent all throughout from the beginning. As far as consistency is concerned, that is consistent. But I have seen other neighbors who said that there was a relationship between the accused and the deceased. Both of them had eloped on that night. And then people apprehended them, recovered the girls, informed the parents. Parents did not come. And then they informed the police. Police came and took both the accused and the victim to the police station. So as far as consistency, it is okay. But as far as
But POCSO.
Yes, she is minor.
Minor. POCSO is POCSO.
This is POCSO.
But my lord, the
Yes.
statement of the victim.
How will it matter in a POCSO matter if the age is not disputed?
No, but
15 years.
the statement of victim is to be considered. Under section 161, he stated something else. Under section 164, he stated different person, your lordship. My lord, in chief, my lord, as PW3, he stated different way, my lord. And
We will have the matter, we'll hear the matter.
POCSO matters are found few high court judgments. Between the, of course, they don't go to much lower age, but between 15, 16, 17 years of age girls, where there is a relationship and it is proved by the witness. Then in those cases, some high courts have granted bail and even acquittal.
Sorry.
Because in order
Sorry, we may not endorse.
But
Sir, it will lay the bad precedent, madam. Where do you fix the date?
my lord,
Then I have
Then
seen
16, then
high courts-
15, then 14, then 13.
no, only because of minor.
Just like the juvenile
POCSO.
justice, if it's 18, we even a
No,
day.
the reason given by the High Court is that POCSO Act is for exploitation. This is not
No.
exploitation. This is what.
No, not
And
at all.
my lord, if
We'll
we
hear
go,
the matter.
if we go through the
We'll hear the
evidence
matter.
on record,
Okay.
sir. My lord, may I pray one thing? It's not submission. The accused appellant is suffering from some disease, my lord, and he was admitted in the Dhubri Civil Hospital.
No,
My
if you
lord,
want to argue today, you can argue.
the relatives of the
If you want
accused,
to argue today, you can argue.
my lord, yes, sir.
Appeal.
Yes, your lord.
Yes. It is for hearing only.
My lord, I think it's small matter, my lord. There are only 6 or 7 witnesses, my lord. 7. Bit of.
We'll hear the matter.
Here convicted under section 4. Punishment is from 7 years to life imprisonment. But here punishment has been imposed 20 years, my lord. Maximum punishment has been imposed. Your lordship may kindly come to page 5, your lordship, the FIR.
Has not been reflected in the cause list. Post of para. List for hearing immediately after the Puja vacation by reflecting the name of Miss L. Devi as legal aid counsel for the informant.
But in the meantime,
Immediately after the Puja vacation.
one direction may be given to the jail authority to furnish the medical record of the applicant. To the
No, you are
relative-
hearing on the merits, medical record.
to
will
the
be
relative of the applicant. Your lord. But I have stated in my affidavit, my lord, they approached several times for obtaining medical documents. But
We are
the
hearing the
jail
conviction,
authority,
we are hearing the appeal on merits. How will it make a difference?
for better treatment, my lord, they want to.
State always provide wherever it's required.
Oh.
If
Jail
I don't know, it is submitted that the appellant is suffering from certain ailments. Full stop. Medical, the jail authorities. Madam, your name has not been shown. You're an legal aid counsel.
officer
We are fixing after the vacation. Your name will be shown.
state
Um,
provides
the jail authorities are directed to provide adequate medical treatment
Right.
to the appellant in
Right.
accordance